You turn that key, you love the...
He would kill me if I told on him.
Do you know where your buddy is?
Meet Blake Jefferson, a 22-year-old. Blake Jefferson, a 22-year-old, is facing trial for the fatal stabbing of his 48-year-old mother, Dedre, in their home in Houston, Texas. It was speculated that Blake had overdosed on his mother's prescription medication prior to the attack, although there was no concrete evidence to support this claim. Blake had been battling mental health issues, which had increasingly concerned his mother. On the evening before the incident, Blake asked for guidance from a pastor, claiming he was having spiritual visions. On the night of December 16, 2016, around 2 a.m., Dedre phoned her mother, alarmed by Blake's unpredictable behavior. The situation escalated rapidly, ending in screams heard over the phone as Dedre cried out that Blake was assaulting her. When deputies arrived, they found her lifeless body in the garage.
I mean, it's a sad situation. It's a few days to Christmas. I mean, the lady just literally put up, the Christmas decorations and stuff, so it's bad. I mean, your own child.
After committing the dreadful act, Blake Jefferson took shelter in a neighbor's house, hiding himself in a closet until the police arrived. Concerns about his mental condition and possible drug intoxication prompted his hospitalization for a suspected overdose. Blake's behavior in court was as shocking as his crime. He was formally charged with murder, and his response to these charges during his trial was notably dramatic. After hearing from forensic psychologists, Blake was declared not guilty by reason of insanity in November 2017. His reaction to this verdict was notably different. Despite the turmoil, Blake's family members stood by him, offering their support.
He was brilliant and an humble young man, very smart. He was an all-round individual. I mean, good in sports, good in school. Very respectful. He's still respectful. Yes, ma'am. No, ma'am. It's always been that way with him.
However, he was committed to a mental health hospital for treatment until he could be considered well. This is Todd Kap.
The man who's torn apart so many families has learned his fate.
Todd, a 52-year-old, is charged with multiple counts of kidnapping and murder in South Carolina. Over a period from 2003 to 2016, Todd abducted and killed 7 individuals.
3 bodies buried, a woman found chained alive, and a cold case solved, all by the acts of Todd Kap.
On November 3rd, 2016, Todd was finally arrested. After his arrest, when police searched his house, they found evidence that left them utterly shocked.
Just a girl. How are you, honey? He's a paramedic, sweetheart. Oh, yeah. Okay, we're going to get you out of there, okay?
Do you know where your buddy is?
Charlie.
Yes.
Who did?
Douche.
Todd Kap. Charlie Carver 3 times in the chest, wrapped him in a blue tarp, put him in the bucket of the tractor, locked me down here, and I never seen him again.
During his interrogation, Todd was forthright and did not hold back.
I met her there, okay, got her number, and I picked him up, got her down to my building, and that's when Johnny pulled out, and
you shot. So then you shot him how many times?
Twice.
Okay.
In the chest.
Okay. And you shot her?
Not exactly. Him set the back tight in the back. Got her to calm down, but I had her cuffed, and she wouldn't go anywhere. I held her there for a couple days.
In court, Todd listens attentively as family members of his victims express their feelings and the impact of his actions.
Sorry that the events that led to such a gruesome day had to happen at all, because there was always a better way to deal with things.
I forgive you. I'm not fully there yet, but I don't hate you. I just miss him so much.
Ultimately, Todd accepted a plea deal that spared him from the death sentence.
Firm believer in the penalty. This was a penalty case. It's not fair to these family members to wait years and years and years for justice.
However, he was sentenced to life imprisonment without the possibility of parole and showed no remorse for his crimes.
Take this crop duster.
Todd is currently serving his life sentence at the Liber Correctional Institute. Williams Hammonds, a 24-year-old from Cleveland, Ohio, became widely known during a high-profile murder trial. While the crime itself was significant, it was Hammond's striking appearance that captivated the public. With a chiseled jawline and impeccably styled hair, he quickly drew widespread attention. However, beneath his attractive exterior, Hammonds harbors a dark and troubling past. Williams Hammonds was part of the infamous Heartless Felons gang, notorious for their involvement in violent crimes and drug trafficking throughout Cleveland. The gang's activities instilled fear in the community. Hammond's involvement went beyond minor offenses. In 2012, he participated in a horrific murder that shocked the city. The victim, Sharon Anderson Norfus, was brutally beaten and left for dead, highlighting the severity of Hammond's criminal activities. On May 4th, 2012, according to police reports, Hammonds used a key fob to access the Shaker Heights apartment building on Warrensville Center Road, where Sharon Anderson Norfus lived. Inside her apartment, he sexually assaulted the 60-year-old makeup artist and demanded her ATM card and PIN. When Anderson Norfus attempted to escape, Hammonds strangled her. The evidence against Hammonds was overwhelming, leading to his conviction for aggravated murder. The details of this crime were both gruesome and shocking. The community's outcry for justice led to Hammonds being sentenced to life in prison without the possibility of parole, plus an additional 100 years. This sentence highlighted the severity of his actions and conveyed a strong message that such violent acts would not be tolerated. While serving his sentence at the Southern Ohio Correctional Facility, Hammonds remained in the headlines. He sent death threats to Judge Michael Astrab of the Cuyahoga County Common Pleas Court, who had presided over his murder trial. This act of retaliation secured his image as a dangerous and unpredictable individual. Hammonds pleaded guilty to 1 count of retaliation, a 3rd-degree felony, along with 3 misdemeanor counts of aggravated menacing. He was sentenced to an additional 36 months in prison for these offenses. Stephanie Melgoza, a 24-year-old woman from Illinois, received a 14-year prison sentence after causing the deaths of 2 people in a drunk driving crash in 2022. Disturbingly, police body camera footage showed Melgoza singing and smiling in the aftermath of the tragic collision.
Come over here with me, man, okay?
I called as soon.
So here's what I'm going to have you do. If you can maybe help Pyro doing CPR on that one right now.
Someone, your friend took my license.
Do you have a driver's license?
Your friend took my license.
Okay. I'm just going to... What is your first name?
StephanieE. My night started.
So were you going this direction or this direction?
I was coming this direction.
All right, the red car? Yes. You were the only one in the vehicle?
I'm the only one.
Okay, come over here to my squad car, okay?
Yep.
Yep. Do you have anything illegal on you?
Yes, I have marijuana in
your purse. Okay.
As soon as something happened. And then someone said, oh, someone else has said, I'm just like, oh my God. How?
Okay.
But I promise you, like, I only know one person got hit, and I'm just like, they came on a
if you had to ask me, how fast were you going when you hit the person?
40.
Do you think
maybe 40 to 45, but at least 40.
Okay. All right.
41 on Sterling Avenue.
Tavern 31 on
41.
Tavern 41 on Sterling.
I had water, so I was staying hydrated, you know, and drinking.
On it.
Like right now, if you had me...
Yeah, we got your purse, your phone already, and that's all we need out of your car, right? Yeah. Okay, hang tight.
Can I blink?
Yep.
Okay, let me blink, please.
Okay, go up. Keep your head straight, just look up with your eyes. One more time on that. Okay. Right here, face my car. We don't have a line. We're going to pretend there's an invisible line straight from you to my license plate, okay? You know what the legal limit is to drive in Illinois?
I do not, sir.
Okay, 0.08, okay? I'm going to have you do a little bit harder for me, a little bit harder. Keep going, keep going, keep going, keep going, keep going. Okay.
While sitting in a hospital bed, Stephanie Melgoza blankly stared at Officer Jeffrey Bieber of the East Peoria Police. In a moment of brutal honesty, he confronted her, telling her she would be going to jail without the possibility of bond due to the crash she caused, which resulted in the deaths of 2 people. Despite the seriousness of her situation, Melgoza seemed unfazed as she nonchalantly asked about attending her night class later that week. Officer Bieber, taken aback by her lack of remorse, described her demeanor as sad, pathetic, and horrifying. Officer Jeffrey Bieber challenged Stephanie Melgoza's understanding of the severity of her actions, emphasizing that her reckless behavior had ended the lives of 2 individuals. He confronted her about her apparent indifference and heartlessness. Even when asked to speak merely as a police officer, he affirmed that he could express the same sentiments in his official capacity. Displaying a disturbing lack of remorse, Melgoza then shifted the conversation to her upcoming birthday trip to Las Vegas, where she planned to indulge in drinking. When Bieber questioned her about her alcohol consumption habits, she laughed it off, suggesting that there are no limits in Las Vegas. It was revealed that Melgoza had called 911 after the crash, which occurred outside a bar named Full Throttle. During the investigation, Melgoza confessed to drinking 3 vodka drinks and mentioned that her evening had only just begun when the accident happened. A police report revealed an open bottle of Tito's vodka on the car's floor. Melgoza asked about how her actions would affect her upcoming graduation, showing concern for the consequences. In February, she pleaded guilty to 2 counts each of aggravated DUI and aggravated reckless driving. She apologized, expressed remorse, and vowed never to behave in such a way again. Authorities have charged a Florida teenager with vehicular homicide after he was found driving at 151 miles per hour in a crash that resulted in the deaths of 6 people. Prior to the accident, the teenager had posted videos of himself driving even faster and had asked people to guess the speeds in exchange for $25. Noah Thomas Gall, 17, was charged with 6 counts of vehicular homicide on Tuesday after crashing his 2019 BMW M5 into an SUV carrying people in Delray Beach on January 27th. When a deputy en route to the hospital asked how fast he had been driving, Gale allegedly replied, above 120. Investigators from the Palm Beach County Sheriff's Office suspect that the Wellington resident, who sustained minor injuries, was under the influence of alcohol and/or drugs at the time of the 10:58 p.m. crash. During the investigation, a tip-off led police to discover that Gale had recorded himself driving at an extremely high speed 2 weeks prior and had posted the footage on social media. When police executed a search warrant for his social media account, they found footage of him driving at 182 miles per hour on Interstate 95 in the same luxury BMW. In the comments section, the teen allegedly offered $25 to the first person who correctly guessed the speed. The paper cited a BMW dealer website stating that a standard 2019 BMW M5 is electronically limited to 155 miles per hour, but the competition model, priced at about $111,000, can reach speeds of 189 miles per hour. However, the police report did not specify which model Gale was driving. In the crash on January 27th, Gale collided with the rear of a Nissan Rogue, resulting in the deaths of driver Myrlane Jolcius, 44, Ramiz Michel, 52, Marie-M Louis, Philen Dieu, 45, and Venice Persina, 28. The name of the 6th person has not been released. These 6 individuals were reportedly workers leaving their jobs at Piero Family Farms. An accused MS-13 gang member has been sentenced to more than 3 years after admitting guilt for his involvement in the tragic death of a girl from Lynchburg in 2017. One of the suspected MS-13 gang members accused of killing Raymond Wood on March 27, 2017, is Lisandro Antonio Posada Vasquez. In September 2018, Posada Vasquez pleaded guilty to capital murder, robbery, kidnapping for financial gain, and participating in criminal conduct as part of a street gang. During his sentencing hearing, he was given a life sentence for the murder and kidnapping charges, with a 75-year suspension. Additionally, he received a 10-year term for his membership in the gang. Wes Nance, the Commonwealth's attorney for Bedford County, stated that he and Wood's mother decided to seek a harsher punishment, considering Vasquez's acceptance of responsibility for his actions. Nance emphasized that despite Vasquez's admission of guilt, a life sentence was still warranted due to the severity of the offense. Even though Vasquez confessed, Nance believed that the nature of the crime warranted a significant jail term. Wood's body was discovered in the 1700 block of Roaring Run Road in Bedford County. During Posada Vasquez's 2018 trial, the prosecution revealed that Wood had been coerced into leaving his house under the guise of a drug transaction, kidnapped, and taken to Roaring Run Road, where he was found with 29 stab wounds to his torso, a severed hand, and a slashed throat. Prosecutors alleged that Posada Vasquez was responsible for stabbing several of the victims. They argued that the murder of Wood was particularly brutal because the accused individuals took turns stabbing him, with the severity of the wounds indicating the victim's rank within the gang. Nance stated that the Wood family had already overcome one obstacle with the sentence handed down.
For Raymond Wood and his family.
It's one more defendant who has finally reached a day of justice, Nance said. A courtroom erupted into chaos on Wednesday as the family of the victim, who was fatally shot execution style, confronted the accused perpetrator. Jeffrey Clark faced charges, including first-degree premeditated murder, for allegedly killing Robertson in cold blood in the early hours of July 4th. Robertson attempted to flee for his life during the incident. A woman with romantic connections to both men testified in court, revealing that Clark had threatened her following the shooting.
He proceeded to tell me that he would kill me if I told on him. He told me exactly what he did to Mr. Robertson. He told me that Mr. Robertson begged for his life, and that the only thing he was worried about was that he was on tether.
Around 3:15 in the morning on the 4th of July, police arrived at the intersection of Joy and Franklin and Frazier, where they discovered Robertson lying on the ground with multiple gunshot wounds. Video of the shooting was played in court, but its graphic nature prevents us from showing it here. It was shortly after the video was played that the courtroom erupted into chaos.
That we witnessed this.
It's an emotional case. I mean, obviously we have an individual who was repeatedly. We have members of the victim's family, the defendant's family were present, so it's no surprise that emotions are involved. It's unfortunate that they decided to let those emotions unleash in the court.
Another defendant charged in the case, Tamara Scott, waived her preliminary hearing and was bound over to circuit court. Sounds like this lawyer really loves talking.
It would cause harm. Now, Attorney Pattis is still free to argue at any point that the harm caused here wasn't what the plaintiffs alleged. That's what he's apparently claiming. But Mr. Jones's response to that question, if the answer is yes, one would expect that type of harm. That doesn't violate the court's orders, and it's not false. If the answer is no, one wouldn't expect that. That doesn't violate the court's orders, and it's not false, right? So either one. He can testify truthfully without violating the court's order and putting himself in contempt.
Or I don't know.
Or I don't know.
All right, so how is...
with that, Judge, is it's argumentative in tone. He's not an expert, and so what one does isn't what we're here to show. We're here to show what he did.
Right, but that's a different... No, Attorney Pattis, how many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So... your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish so I don't want to follow your order. I have been in offshore work for a long time. As you know, I insist on making my record, so thank you. And I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely improper, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of all of his proffer outside the jury's presence, he's now switched it to one would expect. That is simply not relevant. That's argumentative. He's a fact witness. His state of mind about his conduct is...
I can't disagree with that. So I will sustain the objection. And where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So there's a question. You're going to invoke on his behalf?
I can't do that, I don't think. It's certainly the jury's presence. I'll argue, I'll simply say
in a
motion
civil
about
case.
invocation. Motion about invocation.
Okay. Does that work, Attorney Maddie?
Sure, that's fine.
Okay. So if that happens, Mr. Jones, if that happens, just put the brakes on, okay? So that we can do that. Okay, let's bring the jury out. So can I just see counsel in the meantime?
On April 25th, 2021, Jennifer Carvajal of Tampa was arrested following a fatal high-speed collision on I-4 in Hillsborough County. Carvajal was observed traveling at least 3 times the speed limit and did not decelerate. Florida Highway Patrol initiated a high-speed pursuit, but Carvajal made a sharp right turn, causing her Hyundai Elantra to swerve onto the shoulder. The vehicle then descended an embankment, became airborne, and traversed over a fence before colliding with a car dealership. Carvajal sustained minor injuries and was the sole occupant wearing a seatbelt. Criminal charges have been filed against Carvajal for reckless driving, DUI, DUI with property damage, driving without a driver's license, and violation of probation for DUI manslaughter. Speeding is a common cause of fatal accidents in Tampa, with Florida statute emphasizing that drivers must operate their vehicles at a reasonable and prudent speed considering the prevailing conditions and potential hazards. Carvajal was driving at least 46 miles per hour over the speed limit, and in most states, penalties escalate based on the extent of the speeding violation. In Florida, exceeding the speed limit by 29 miles per hour can result in a ticket, while surpassing it by over 50 miles per hour can lead to a felony conviction. Carvajal's prior record could increase the likelihood of the family of the deceased individual suing her for wrongful death damages. In addition to compensatory damages, a judge may award the family separate punitive damages. In Florida, punitive damages are capped at greater than 3 times the compensatory damages awarded to each claimant, or $500,000. The judge calls out Kevin for his attitude.
It's going to be the day. You see it in Cher's text. She knows he's coming in town. The baby shower. The 18th is going to be the day I'm supposed to be there, but I'm not. I'm in Batesville, and I'm calling Billy. Every time. And they do it without me. And I know it because they show up at my house. Metal detector. Cut the barbed wire fence. Look for the... Go to the lake with Billy and throw the away. Shells, wire clippers, everything. It's all the same. And it's been the same, literally, for 10 years. Through 20 interviews.
Objection, Your Honor. This mischaracterization.
20 interviews.
That's the proper argument to your argument. You may proceed, Mr. Okay. I'm sorry, Mr. Perry, did you say something?
I didn't say a word.
I told you about that attitude. You would not, under your breath, be disrespectful to this court, sir. You argued things he has a right to ask for. When I overrule your argument, to have you sit down and say, of course it is. It is a proper. Mr. Perry, it's a proper argument to your argument. You may proceed, Mr. Ashman.
Yes, sir.
It's been over a year and a half since a drunk driver claimed the life of a high school senior. The Romulus man responsible for the tragic incident faced consequences for his actions. Mia Howard's mother was given the opportunity to speak on behalf of her late daughter and confront Robert Merritt, 56.
My life, from the moment she passed, has been demolished. My family's life, her friends, the community.
Merritt will spend the next 6 to 15 years in prison as part of a plea agreement for the murder of Mia Howard, 17, on September 22, 2021. Merritt was driving while intoxicated near Goddard on Middle Belt when he collided with Mia. According to reports, his blood alcohol level at the time was 0.14.
This is not an accident. And when people understand that you get behind a wheel, you turn that key, you love the... When you start driving, you aim that. And when you hit, hurt, injure, and when Robert Merritt hit my daughter, he pulled that trigger.
Faith, Mia's cousin, was also injured in the incident. They had been spending time together earlier, as they often did.
And Mia grabbed their stuff. Told them I loved them. She walked out my door. And I will never see her again.
Merritt, who was present in court, initially pleaded not guilty to second-degree murder without making any statements. He stood in the courtroom, visibly moved, wiping away tears as he listened.
Looking at everybody and listening to everybody, and my heart is with them, the family.
The most beautiful human, inside and out. Her heart is so loving and so caring and so compassionate. To be loved by her was more than to be lucky.
And Jeanette Marie Welk, whose widely circulated smiling mugshot gained attention, cried in a Florida courtroom during her manslaughter sentencing. Welk of Ocala, also known by her married name Missit, was sentenced to 11 years in prison, a $5,000 fine, and 15 years of probation for causing a 3-car crash that resulted in the death of 60-year-old Sandra Clarkston. The incident occurred on May 10, 2018, on a Florida highway, when Welk's Chevy Avalanche collided with a car driven by Sheann Kroll, 18, of Seattle, and her mother, Sandra Clarkston, 60. Kroll's car struck a horse trailer attached to Ocala resident Kevin McMinn's truck. While Kroll and McMinn escaped serious injury, Clarkston tragically passed away at Ocala Regional Medical Center. At the scene, Welk appeared lethargic, slurred her words, and emitted a strong odor of alcohol. 2 field sobriety tests indicated that her blood alcohol level was twice the legal limit in Florida. Welk's mugshot garnered significant attention on the internet, with many describing it as astonishing. However, defense attorney Stacey Humans portrayed her client as a good-hearted person, a wife, mother, and friend who is devastated by what happened. Unfortunately, Welk found herself in trouble again when she was arrested on a DUI charge, resulting in a less cheery mugshot on May 19, 2018. A week after the crash, Welk married Eric John Missit, 46, at Ocala Community Church of Christ, as reported by Ocala News. They swiftly obtained their marriage license from the Marion County Clerk's office. Following their marriage, the couple relocated to Washington State with the permission of a judge.
Do you wish to plead to those charges?
No.
Be prepared to prove that on May 10, 2018 at approximately 11:50 a.m., the defendant was driving the speed limit. She was distracted by her telephone, and as she approached the intersection of US 27 and the result, Ms. Clarkston was taken to the hospital. The defendant provided a sample. That sample was analyzed at 8 p.m. The defendant had a alcohol level of 0.189 and 0.1.
We're pending the results of the precinct's investigation, and again, you will be remanded into custody pending that.
I don't think she should have been able to the vehicle and not. I think all too often this happens, and I don't agree.
Missed, She did no harm to nobody. Sitting there the day after her birthday, wanting to go have fun, the day after her birthday, and probably lives 12 hours.
It sounds like we have a situation involving a Karen who is seeking increased financial support from her ex-husband through a lawsuit.
I come here today to try to get his child support raised.
Okay.
We have one child. His business, I'm not 100% sure, but I think it's almost close to $100,000, give or take, maybe 10 to 15.
Okay.
So I feel like I get a measly $600 a month from him. I feel like something's not right.
The judge then inquires with the father about his income, questioning whether it aligns with the amount that his ex-wife is asserting she earns.
Not a good year.
Okay. All right. What is it that you do?
I'm a mechanic.
Mechanic. Okay. All right. So you said 90 on the high end.
Yes, ma'am.
Okay. I can only go off of what he told me, and he said 90,000 on the high end. I think you're in pretty good shape.
After confirming the father's earnings, Judge Vonda questioned the mother about her reported income asking if she would deceive the court regarding her earnings. The mother's response to this inquiry was unexpected.
He is
11? He goes to school?
He does.
So what do you do during the day?
Nothing.
You don't want to work?
No.
So you're just living off of his child support?
She then continued by explaining why she was reluctant to seek employment.
Living with him, and I was a stay-at-home mom. He made the income.
Okay.
But, I mean...
But you can work now, right?
I can, but...
So it's no but you can go get a job, right?
I could, but I'm not going to. My rent's free, my food is free. I mean, my mom's the homeowner. We don't have to pay nothing.
Upon learning the amount of financial support she will receive, this mother reacts with shock.
110. So what I'm going to do is give you credit, actually, for the health insurance coverage for the child. So that will slightly bring your child support down. And monthly, yes, slightly. It's still expensive. $1,093 a month is what he would pay in child support.
That's it?
That's it. Well, it would be more if you get a job.
He would pay more if I got a job?
No, it would be more for the child if you got a job.
Your Honor.
Ma'am. No,
you don't
no.
understand.
Instead of reflecting on the situation, this mother maintains her defiant attitude until the very end.
What it is that he makes. Nothing
he
more.
He makes more than that.
Until you bring me something in here to show me that, that's what I'm going to base it off of. And again, you can work. What is it? Make it quick.
I promise you I'll make it quick. Let's say that you have a battery-operated vibrator.
You know what? We're done right there. We're done. Is there anything further
You're
from
about
you,
to
sir?
climax.
Okay. Well,
the batteries go out.
Okay, thanks.
That's him.
Okay, great.
A gang member who fatally shot an unarmed college student in front of a Halloween party in La Habra 8 years ago has been sentenced to 50 years to life in prison. David Anthony Parga, 28, was found guilty of second-degree murder in the killing of Leland Washington on October 29, 2006. Washington, a 27-year-old Cal State Fullerton student, was just a semester away from graduating with double degrees in accounting and business administration, according to his brother Willie Washington III, who described Leland as not only his elder brother, but also his closest friend.
There's days that the grief is so much that I just kind of through the day. You have to understand who he was. He was such a great person, and the way that he did not deserve that at all.
Washington described his brother as a talented but humble athlete and a soft-spoken individual whose demeanor earned him the nickname Cruise Control on the football field. The victim's sister, Denise, as well as both of his parents, also addressed the court during the proceedings.
He couldn't have been anything but a friend to him. He couldn't have found any other way but to make him a friend.
The court branded the defendant a coward for approaching the victim and shooting him 4 times, seemingly without provocation. This was a senseless and very stupid killing of a young man about to graduate, remarked Bromberg. The defendant's actions were as ice cold can be, and that's what makes you a coward, the judge added. According to Senior Deputy District Attorney Jim Mendelson, Parga murdered Washington because he belonged to a group that had returned to a party after being asked to leave, which was seen as disrespectful to the defendant's gang. Mendelson explained that friends invited Washington, who had no affiliations with any gangs, to the party. After the host asked them to leave, he and his friends were outside when Washington was shot with a .22 caliber handgun by Parga shortly after. Mendelson detailed that the bullets tore through Washington's aorta, liver, and small intestine, causing him to bleed to death internally. According to Mendelson, Washington's friends were urged to get him out of the area because they couldn't wait to call 911. Washington was then driven by friends of the victim to the nearby La Habra police station. The prosecution stated that after being transported, he passed away shortly after arriving at UCI Medical Center. According to Mendelson, Parga's DNA was discovered on a shell casing at the shooting site. She also asserted that a female witness informed detectives that the defendant admitted to the shooting and instructed her to dispose of his bloodied clothes. During his remarks, Parga directed his comments to the family matriarch, claiming to believe that the victim's father, brother, and sister held animosity towards him.
I know there's nothing I could do to bring you guys' brother back, but I am deeply sorry for what happened to him.
James Egan Holmes is infamous for the 2012 Aurora, Colorado shooting at a movie theater where he killed 12 people and injured 70 others. He had no criminal history prior to this incident. Before the attack, Holmes rigged his apartment with explosives, which were later safely disarmed. Following his arrest, he pleaded not guilty by reason of insanity. His trial commenced in April 2015, and on August 26, 2015, Judge Carlos Asamor sentenced him to 12 consecutive life sentences, plus an additional 3,318 years, without the possibility of parole. The jury decided against the death penalty by 1 vote. Judge Samor made it clear that Holmes would never be free again. The incident involved Matthew Terry, a 47-year-old man who on May 27, 2022, in Hillsborough County, Florida, took the life of his 43-year-old ex-girlfriend, Kay Baker. Following an investigation, police charged Matthew with the crime. In court, a friend expressed her emotions, stating, "We value friends second only to family."
11:49:51, is that you ending the phone call and putting the phone back down?
Yes.
Would it be fair to say that that phone call, to the best of your recollection, lasted about a minute?
Yes.
During that minute, are you positive, are you 100% certain that you recall Kay Baker calling you because Matthew Terry was still accusing her of dancing with another man?
Yes, I am.
And do you recall having to again tell the defendant he was being jealous and to stop it?
Yes.
And do you recall hearing him acknowledge you when you told him he was being jealous and to stop it?
Yes.
Somewhere shortly after this phone call, did you receive a text message from Miss Baker?
I did.
And do you remember what that text message was about generally?
Yes, I do.
Okay. Your Honor, if I could approach. This is States 54. I should mark these. A and B. Ma'am, did you have a chance to look at these before court?
I did.
Do you recognize those?
Yes, I do.
As to 54A and B, do they fairly and accurately depict both the call log from your phone as well as the text message you received from Kay Baker?
Yes.
Your Honor, I move into evidence States Exhibit number 54A and B.
Any objection? No objection. Admitted.
So I'm going to play the video again just so I don't have to jump back and forth. I'm going to move to 11:56. We'll pick up here at about 11:55:25. At about 11:55:42, it looks like you're looking at your phone. Is that correct?
Correct.
Do you remember what you were doing at this moment?
Probably checking to see if the Uber was on its way.
So you've not yet received this text message?
I don't believe so. I think it was a little after.
There was a period of time there where you were using your thumbs to do something with the phone, and then you stopped and made a comment to your husband and were talking. Do you remember if that's around the time you received the text message from Kay?
Yes.
When you received that text message, did you take the time to respond to her?
I did.
When you hold your cell phone, are you the kind of person who like hunts and pecks with their index finger, or do you type with your thumbs?
I type with my thumbs.
Your Honor, I'd ask for permission to publish State's Exhibit number 54. This is State's Exhibit 54B. Is this a photo of your phone depicting the call log from Kay Baker at 11:48 that lasted approximately 1 minute?
Yes.
States 54A. Is this the conversation you had with Kay Baker at 11:56?
Yes, it is.
So for anyone who doesn't know how text messaging works in the modern era, if any such person exists, on the left, there's a box in sort of gray. Whose text message is that?
Case.
And then on the right, there's boxes in green. Whose text messages are those?
Mine.
Okay. And so if you would, could you read the gray box that you're attributing to the text message from Kay Baker?
It says, LOL, sorry for that, so dumb, all good now.
And I guess that's a little smiley face?
Yes.
And then the next text message that you send back is what?
Tell Matt to stop being stupid or I'm going to punch him in the balls.
Did you mean that literally? Are you literally going to punch somebody in the balls?
No.
Why were you saying that?
I really wanted him to stop being jealous and to drop it and stop the fight.
Is this the last conversation you ever had with Kay Baker?
Yes, it is.
The next morning, did you wake up to news from either the actual news, like on TV, or from other people who were text messaging you, or whatever the case may be?
Yes, I did.
And did you have reason to suspect that something might have happened to Miss Baker?
Yes, I did.
I'm not going to put it back up, but there's a text message there at about 9:32 in the morning asking Miss Baker to call you or text you. Is that because you were already trying to figure out where she was and if she was okay?
Yes.
At some point, did law enforcement reach out to you and ask to talk with you?
Yes, they did.
Did they meet with you and your husband?
Yes, at my house.
Did you provide them information regarding what had happened at the Landing Bar the night before, as far as going to the bathroom, crossing paths, the other guy, the little dancing, all of those sorts of things?
Yes, I did.
Are you aware of any moment that is not on video that we've already seen where Kay Baker is dancing with another guy?
No.
Was there any portion of the conversation that night where the defendant suggested there was some other moment in time where his girlfriend was being unfaithful and dancing with another guy?
No.
That's it.
That's it.
After considering all the arguments presented, the jury delivered their verdict.
The jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good evening, I think, is appropriate at this time, but welcome back. My deputies have advised, well, first, my question to you is, were you able to select a foreperson? Who is the foreperson? All right, so that is Mr. Williams, correct? So my next question then is to you as the foreperson, Mr. Williams. Was this jury able to reach a unanimous verdict in this case?
Yes, Your Honor.
And do you have the verdict form?
Yes, Your Honor.
If you would please present that to the bailiff. Thank you. Bailiff will present it to me. I will review it, and then I will give it to the clerk to be published. Thank you. Today is the 15th, right? All right. I'm going to ask Mr. Terry, with your attorneys, to please stand for publishing of the verdict, and I will present the verdict to the clerk to be published.
State of Florida versus Matthew Robinson Terry. We, the jury, find as follows as to count 1. A, the defendant is guilty of first-degree as charged, and with further findings, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. So say we all, dated this 15th day of November 2022, foreperson WW.
Thank you. Madam Clerk, you may be seated. Would either side like the jury polled at this time?
Yes, Your Honor.
Ladies and gentlemen of the jury, what that means is the clerk is going to ask each one of you individually whether the verdict that was published is in fact your true verdict in this case.
Juror number 1, MK, is this your true and correct verdict? Yes. Juror number 2, WW, is this your true and correct verdict?
Yes.
Juror number 3, B.J., is this your true and correct verdict?
Yes.
Juror number 4, K.A., is this your true and correct verdict?
Yes.
Juror number 5, J.A., is this your true and correct verdict?
Yes.
Juror number 6, V.R., is this your true and correct verdict?
Yes.
Juror number 7, D.T., is this your true and correct verdict?
Yes.
Juror number 8, S.L., is this your true and correct verdict?
Yes, sir.
Juror number 9, M.J., is this your true and correct verdict?
Yes.
Juror number 10, M.B., is this your true and correct verdict?
Yes, ma'am.
Juror number 11, S.T., is this your true and correct verdict?
Yes.
Juror number 12, B.S., is this your true and correct verdict?
Yes.
Thank you. Is there anything from either side before I send the jury into the jury room so that we can have further discussions? All right. Ladies and gentlemen of the jury, as you may recall during selection and the talk about 2 phases, because of that verdict, we now will proceed to phase 2. What I'm going to do is, we're not going to do that tonight. What I'm going to do is I'm going to send you back into the jury room so that I can have some discussions with the attorneys regarding a schedule for that. So please, I will now ask you to, you were allowed to discuss the case amongst yourselves during the deliberations, but I'm going to now ask that we go back to previous instructions. You are not to discuss anything about the case amongst yourself or with anyone else. You are not to do any research related to the case, and you are to avoid any contact with this case, about this case, outside of the courtroom.
The judge is responsible for administering justice. After a lengthy trial, the judge issued a sentence.
Yes, please stand. I guess in one respect it is easy, since Mr. Diaz is absolutely right and that I don't have any discretion. There is only one sentence. What I will say is that I listened to the testimony of Ms. Rogers both during the Williams Rule hearing and during the trial that we've been in here, and additional testimony regarding the charges, the trial, the sentence in Michigan. I don't know what happened in Michigan as far as the trial and the sentence, but based on what I heard, I believe that you should have been in prison in Michigan and that Miss Baker should still be alive. This is Florida. You're going to prison for the rest of your life. I adjudicate you guilty. I sentence you to life in prison. I impose all fines, fees, associated charges, and I advise you that you have 30 days to appeal the judgment and sentence entered against you. Thank you. He has 174 days credit. State, any objection?
No, Your Honor.
All right. Thank you all very much. Thank you.
After connecting on a dating app, Emily Todd, a 2012 graduate of Ansonia High School, began a relationship that eventually ended. On December 8, 2018, Roberts enticed her to a boat ramp in Bridgeport, where he tragically ended her life and stole her car. The following 3 years were a period of deep pain and waiting for justice for Emily Todd's family. When the verdict was finally announced, a collective gasp filled the room as the 12-member jury found Brandon Roberts guilty of homicide with a firearm, felony homicide, first-degree robbery, and carrying a pistol without a permit. Roberts behaved indifferently differently during the trial, standing emotionlessly between his attorneys. State Superior Court Judge Alex Hernandez later sentenced the 29-year-old Roberts to 60 years for homicide, 15 years for first-degree robbery with a deadly weapon, and 5 years for carrying a pistol without a permit, all to run concurrently, according to the Fairfield Judicial District's clerk's office. This long-awaited verdict brought some measure of closure to the grieving family of Emily Todd. A routine hearing is taking place at the Owsley County Courthouse in Boonville, Kentucky, presided over by Judge William Bo Leach. Shane Bird stands accused of driving under the influence, an incident that left a young woman injured. The proceedings have been straightforward, with Bird agreeing to a $500 restitution payment to the injured woman. Satisfied with the resolution, Judge Leach prepares to move on to the next case. However, unknown to him, tensions are escalating in the public gallery, setting the stage for a unique disruption. What unfolds next is unlike anything Judge Leach has ever witnessed. In the back row of the Owsley County Courthouse sits Ingrid Bird, the blonde wife of defendant Shane Bird. Directly in front of her, Peggy Gabbard, the dark-haired mother of the injured woman, is visibly upset. The two are clearly not on good terms. As Judge William Bo Leach starts on the next case, tensions in the gallery suddenly explode, disrupting the courtroom.
Seatbelt.
Just in case you didn't see it, here's what happened. Ingrid Bird reaches out and grabs Peggy Gabbard during a scuffle. Gabbard then grabs Bird with her left hand and lands a solid right punch to Bird's face, sending her staggering backward. Deputies rush up the aisle toward the commotion as the rest of the gallery watches in shock and some amusement. A woman wearing a striped shirt pushes past the deputies. As they try to hold back, Ingrid Bird, the woman in stripes, jumps to Bird's defense and starts shouting at Gabbard. As the tension escalates, even Shane Bird gets up and walks up the aisle to see the commotion. Meanwhile, the women continue to exchange insults. Ingrid Bird is eventually pulled away by officers, and as she leaves the courtroom, calm is restored. However, the disturbance is far from over. Judge Leach, visibly upset by the disorder, decides to assert his authority to regain control of the courtroom. He points out the woman in the striped shirt, directing her to the jury box, and signals the court deputies to identify and detain anyone else involved in the disturbance.
Lady with the red purse, you need to go to the jury box. Who else was involved in that fight?
Judge Leach calls out the defendant, Shane Bird, and strictly warns him before sending him to join the woman in the striped shirt in the jury box.
All right, Shane Bird, you got up out of the jury box, and I told you not to when you were running over there saying that was your wife.
Asserting his authority, Judge Leach sentences everyone involved in the disturbance to 30 days in jail for contempt of court. He delivers some harsh words to the group, emphasizing the importance of respect and order in the courtroom before the deputies lead them away.
Everybody that was in that's getting 30 days in jail on contempt.
Ultimately, 4 people, including Ingrid Bird, are charged with contempt due to the brawl. Ingrid also faces an additional charge of assault. Before resuming the day's cases, Judge Leach promptly warns the rest of the courtroom about maintaining decorum. With his message clear, normal proceedings then continue.
Breaks out anything today, you're going to get 6 months in jail on contempt. If you want to try me, you wait and see if you don't get 6 months in jail.
Given the high stakes and intense emotions often present in courtrooms, it's unsurprising that they can sometimes erupt in chaos over seemingly minor triggers. The tension and nervous energy can lead to unexpected outbursts. Lonnie James Pebbley from Colorado has been sentenced to 736 years in prison for his involvement in a 2012 Independence Day shootout with police in Castle Rock. During the confrontation, Pebbley fired nearly 70 rounds from an AK-47 at 27 officers, miraculously not hitting anyone. A SWAT team was deployed, and after a 7-hour search, Pebbley was apprehended at a different location. He was subsequently tried and found guilty of 46 criminal charges, including 15 counts of attempted first-degree homicide, 12 counts of first-degree assault, 17 counts of reckless endangerment, 1 count of criminal mischief, and 1 count of reckless use of a firearm. During the sentencing, Judge Paul King specified that the sentences for each count against Lonnie James Pebbley should be served consecutively, emphasizing the severity of his crimes. Sheriff Tony Spurlock described Pebbley as a calculating, dangerous criminal who showed no remorse or value for human life. He expressed relief that Pebbley would no longer threaten the community. Castle Rock Police Department Chief Jack Coley voiced his satisfaction with the outcome, highlighting that justice had been served. He noted that Pebbley, a convicted felon, would be held accountable for his actions and could no longer endanger the lives of law-abiding citizens. Anthony Rodriguez was convicted of assaulting a deaf woman at Martin Luther King Park in Bakersfield. Recently turned 18 and on parole, he dragged the 25-year-old woman about 105 feet into a bathroom, where he robbed her. With a history of prior arrests for violent behavior, this incident marked a significant escalation. Throughout the court proceedings, Anthony remained silent and unresponsive. However, his calm demeanor shifted when the judge sentenced him to 25 years to life in prison. Upon hearing his sentence, Anthony Rodriguez broke down in tears, his face turning red as he became visibly flustered. Overcome with emotion, he began shouting obscenities at the judge and protested the fairness of the ruling. Deputies quickly intervened, forcing him to sit back down. Despite acknowledging the severity of his crime, Anthony was clearly distressed by the sentence. His family, too, felt the judge had been overly harsh. His mother later expressed to the media that she believed her son did not deserve a life sentence. Richard DeBate, from Ellington, was sentenced to a total of 65 years in prison, without the possibility of parole after being convicted of killing his wife. The sentence breakdown includes 60 years for homicide and an additional 5 years for tampering with evidence. He also received a concurrent 1-year sentence for making false statements to authorities. The guilty verdict was delivered in May, following a 5-week trial and 2 days of jury deliberations. A significant piece of evidence was activity data from Connie DeBate's Fitbit, which played a crucial role in building the case against him. Prosecutors contended that DeBate had planned to kill his wife and fake a home invasion, as his life was a mess due to an extramarital affair. Throughout the trial, Richard DeBate asserted his innocence, claiming that a masked intruder had killed his wife and then tied him up. However, this account was contradicted by evidence from Connie DeBate's Fitbit, which showed that she was still moving an hour after Richard claimed she had been killed. After sentencing, DeBate's defense team announced plans to appeal the verdict. The emotional toll of the case was visible as Connie's friends and family gathered outside the courthouse, looking for closure and justice for her tragic death. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.